Will Mr. Lapierre be getting on the phone?
Mr. Lapierre is in the room with me, and he'll be handling the rebuttal and just taking my seat after.
Okay. I just wanted to make sure we weren't starting without him separately. Okay, thank you. We are now ready for oral argument for the case of Terry Jones and Christine Jones versus the Glenwood Golf Corporation. We'll start with a sound check. Let's start with Mr. Rubis. Can you hear me? And let me make sure I can hear you. I can see your lips moving, Mr. Rubis, but I can't hear you. Click that little like, there you go.
There we go.
Okay, thank you.
You hear me all right, Ron?
I can. And if you want to turn it off again, then we'll jump over to the appellant. Thank you very much. All right, and we have Zachary Clausen who will be beginning the argument. Is that correct?
Correct, Your Honor.
Okay, I also had a note here that maybe Mr. Larson would be arguing. Is it just
No,
going
Your
to be
Honor.
just you and Mr. Lapierre?
Correct.
Okay, thank you. You may begin, Mr. Clausen.
May it please the court, counsel. Good afternoon. My name is Zach Clausen, and along with Bill Larson and Rene Lapierre, represent the Glenwood Golf Corporation. For purposes of this argument, I'll be handling the initial argument, and Mr. Lapierre will be handling the rebuttal. This lawsuit arises out of a golf cart accident that occurred at the Glenwood Golf Course in September of 2017, involving plaintiff Terry Jones, who was riding as a passenger in a golf cart being driven by his son, Jeff Jones. When they were crossing a bridge at the Glenwood Golf Course, Terry Jones was ejected from the golf cart and onto the creek bed below. The procedural history of this litigation is particularly important for purposes of this appeal. Prior to the lawsuit commencing, the plaintiffs, Terry and Christine Jones, settled their claims against Jeff Jones and with Jeff Jones's insurance company. The plaintiffs then filed two causes of action against the Glenwood Golf Corporation. The first which is a claim pursuant to the owner's responsibility statute, seeking to recover for the negligence of Jeff Jones. And the second is a premises liability claim pursuant to section 344 of the restatement second of torts, seeking to recover for the negligence of Glenwood. Prior to trial, Glenwood moved for summary judgment, which was denied by the district court. At trial, the jury found the released party, Jeff Jones, 100% at fault for the accident. And following trial, rather than discharging the fault of the released party, Jeff Jones, the court applied a set-off for the entire settlement amount between the plaintiffs and Jeff Jones. The plaintiffs then filed a motion for a new trial on the issue of damages, which was granted by the district court. While there are a few issues briefed, at the heart of this appeal is the effect of the release entered into between the plaintiffs and Jeff Jones and the impact that that release has on the plaintiff's claims against Glenwood under the owner's responsibility statute. Because the plaintiffs settled with Jeff Jones for Jeff Jones's proportionate share of the responsibility, the plaintiff's claim against Glenwood under the owner's responsibility claim should be extinguished as Jeff Jones has satisfied all of the fault attributable for his conduct. No matter how the plaintiffs attempt to frame the release that they entered into with Jeff Jones and Jeff Jones's insurance carrier, it's clear that the intention of the release was to release all of the claims that they had arising out of the negligence of Jeff Jones in the operation of the golf cart. The plain language of the release provides that this release and indemnity agreement covers the released party, Jeff Jones's proportionate share of the responsibility for all injuries and damages. Under 321.493, the owner's responsibility statute, there is no actionable negligence on the part of Glenwood. The claim is entirely a derivative based on the fault of the driver, and in this case, Jeff Jones. The statute.
Mr. Clausen. This is
Yes, Your
Justice
Honor.
McDonald. How is this issue on, this is the summary judgment issue, is that correct?
Correct.
And was this legal issue again raised at the time of trial in the form of another motion or an objection to any instruction?
There were certainly discussions with the judge at trial about this, but the judge had already indicated in the summary judgment ruling how he was going to apportion the credit and apply the Comparative Fault Act following trial.
Is any of that in our record? Any of those discussions?
No, I do not believe so, Your Honor.
How does that, just my understanding generally is that issues presented in a motion for summary judgment that are denied are not preserved for appellate review unless renewed at the time of trial, either by way of motion for a directed verdict or objections to the jury instruction. So tell me how we square that with the issue you're asking us to decide today.
Yes, Your Honor. By virtue of the ruling on the motion for summary judgment, the court ultimately indicated how the credit would be applied after trial. At the time that the verdict was entered, there was still no liability or claim for damages on which Glenwood would have to pay by virtue of the credit that the judge ultimately ended up applying. This only became an issue again once the judge ordered a new trial on the issue of damages. The other thing that I would note is on this appeal, error preservation hasn't been challenged by the plaintiffs. Going back to
on Justice McDonald's question, did you resist the motion for new trial on that ground?
I do not
I understand
believe
you resisted and said, you know, the damages are not too low, but did you also resist on the grounds that there's no cause for a new trial because the driver has been found 100% at fault and has discharged his share of the liability?
No, Your Honor, I do not believe that was addressed in the resistance to the motion for new trial.
Because that obviously would be one reason that you believe a new trial is not warranted, right?
Can you repeat the question?
That would be one reason why you think there shouldn't be a new trial, correct?
Correct, in that there's the fault of the released party, Jeff Jones, should have been discharged, but also in that the court erred in not granting Glenwood's motion for summary judgment on the issue that the release of the driver should have released the court under the claim of on the owner's responsibility statute.
Well, counsel, did you do anything to preserve error after the denial of the summary judgment on this issue?
Other than appeal this, I can't point to anything specifically at trial that was done. Coming back to
Should we follow the Biddle case on the legal effect of the release?
yes, Your Honor, there are two specific cases that we want the court to focus on here. The first is the Biddle case, which indicates that there is a single share of liability in any sort of vicarious claim. While the court in the past has indicated that the owner's responsibility statute does not create a principal and agent relationship, the claim still falls under the umbrella of vicarious liability as it imposes liability on the owner for the actionable negligence of the driver. What the Biddle case said and what has bared out in this case is that the single share of liability, here in this case, Jeff Jones is 100% of the fault, is the only reason that Glenwood would be liable on that claim. The other case that we want the court to focus on that deals exactly with this issue is the Bruce's Estate case from the Southern District of Iowa. And in that case, the court dealt with an issue similar to Biddle, but also the identical issue facing this court here today, in whether the release of a driver operates to release the owner under that same claim. The focus on the court in Bruce's Estate was whether or not there was a right of indemnity held by the owner against the driver for the driver's negligence in bringing about that cause of action. Here, just like in a vicarious liability case that is principal and agent or employer-employee, the owner of the vehicle should have a right of indemnity. And because of that right of indemnity would lead to what's referred to in the cases as this circuity of litigation that would ensue by virtue of the hold harmless provision in the release with the driver. Those facts should lead to the release the release of the owner by virtue of the driver's release. Just as
Mr.
a practice.
Clausen, can I ask you another question, please?
Yes, Your Honor.
Can you? I understand what you're saying about Biddle, and that seems to make some sense to me. I'm struggling a little bit with some language in a couple of our cases, Bogdanovich and then Estate of Dean, where the court seems to characterize this as a kind of the owner's liability statute is not really vicarious liability, or maybe some sort of subspecies of vicarious liability. And there's a footnote in the Bogdanovich case, and then Dean discusses it pretty extensively, that says it's really the act of negligence that's imputed to the owner, or the fact of negligence, but the liability is independent, and it's the owner's liability independently. And that seems to be, whether that's right or wrong, I don't know, but at least it creates some ambiguity for me on whether this is truly vicarious liability in the sense that we understand it in Biddle. So can you address that a little bit? It wasn't a great question, but that's kind of where I'm hung up.
Yes, Your Honor. What the footnote that you're referring to in Bogdanovich, well, it talks about the owner's own liability. That liability is still premised off of the driver's negligence. And the footnote goes on to say that even though the relationship between the owner and driver is not a principal and agent relationship, that it still falls under the umbrella of vicarious liability because it imposes liability on the owner for the actual negligence of the driver. In turning to
what is the distinction that the court draws between, and it says the statute does not impute liability to the owner, but imputes the driver's negligence to the owner? I mean, clearly in Bogdanovich and Dean, the court thought it was drawing some sort of distinction between imputation of negligence and imputation of liability. What is that distinction?
I'm not sure about the nature of the distinction, but what I will say is that liability in those cases is based solely off of the negligence of the driver. Turning to the well, and let me rephrase that, while it might not be a true principal agent case or employer-employee as vicarious liability as we know it, it might be referred to as a statutory vicarious liability. But what I do think that the cases and just the language of the statute itself makes clear is that it still falls under the umbrella of vicarious liability. And even though it might not impute the negligence to the owner, it imputes or the owner is held responsible by virtue of that negligence. I just want to address briefly the Estate of Dean case in the Smith versus CRST International cases. Those cases, the Smith case or the Estate of Dean case was a case under the owner's responsibility statute where the owner of a vehicle was attempting to use defenses afforded to co-employees under the Workers' Compensation Act to bar liability and argue that they were immune from liability. The similar argument was advanced in the Smith case, although that was under the airline owner's consent statute. The differences between those cases and this one is those cases were arguing for complete immunity against all of the claims that might have been brought, where here we're just arguing that the effect of the release entered into by the plaintiffs and Jeff Jones bars the claim against the course for that same negligence. The other reason why the court decided that those immunities did not apply to the owners was due to the quid pro quo. That is the workers' compensation system, which is the bargain between the employer and the employee. And the court found that that same relationship did not exist between the owner and the driver of the vehicle. I see that my time has run out. I just want to wrap up briefly. Because the owner's responsibility statute imposes liability on the owner for the actual negligence of the driver, and because Jeff Jones has satisfied that negligence by virtue of entering the release, but also by the language of the release, the claim against Glenwood under the owner's responsibility statute should be dismissed. Thank you.
Thank you, Mr. Clausen. Mr. Rubis?
Can't hear you, Mr. Rubis.
If you want to turn your mic on.
May it please the court, counsel. My name is Steve Rubis, and I, along with Joseph Herbel, represent the appellees in this matter. We prepared and tried this case. I would like to begin my remarks by summarizing some of the foremost issues before this court to consider. Number one is the effect on your ruling as regards the underlying and fundamental principles of the Comparative Fault Act itself, which, among other things, encourages the ability of multiple parties to settle out portions of the claim in multiple party cases and to discourage a defendant from taking another co-defendant hostage, requiring them to go to trial when they want to settle in this type of case. Depending on the ruling of this case, you could be requiring every one of these cases to go to trial for all defendants. And I don't think that is consistent with the underlying principles and purposes of the Comparative Fault Act. I'd like to respond to Justice McDonald's
Mr. Rubis, this is Ed Mansfield. I want to follow up on kind of the line of questioning. Mr. McDonald talked about some cases, but when we actually look at 321-493 in the language of the statute, it says, in all cases where damage is done by any motor vehicle by reason of negligence of the driver, the owner of the motor vehicle shall be liable for such damage. So it's the damages done by the negligent driver are handed off to the owner, or the owner is derivatively liable for it. How is there daylight here? In other words, once the driver settles those damages, how are there additional damages that you're able to recover from the owner? Help me with that.
Because in our view, both the driver and the owner are liable for all the damages incurred by Terry and Christine Jones in this case. And the comparative fault scheme allows us to divide out and resolve our claims with one party and preserve the claims against the appellant in this case. It's one of the fundamental purposes of the
Counsel, if I could jump in, Justice Waterman here. Let's focus on the other provisions of the Comparative Fault Act. Would you agree that because Jeff Jones, the driver, is a released party, that the golf course could not cross-claim against him for contribution. He's immune from contribution, right?
He's immune from contribution by the terms of 668.7. Exactly.
And so isn't a trade-off that whatever fault is the jury places on the driver, that also exonerates the owner?
We don't view it that way because of the very terms of the statute itself. They are still liable for all damages.
The counsel, would you agree that under our cases and the provisions of the Comparative Fault Act, the driver and owner are treated as one party on the verdict form?
They are treated typically as one party on the verdict form.
Okay. All right.
But maybe if I can get back to answering
Sure.
Justice McDonald's question about Bogdanovic versus Muxfeld, it seems to us, and in our view, the liability of the settling party and the owner of the vehicle in this case is independent, and it was not released and specifically reserved in accordance with the language of the Comparative Fault Act in the release that was signed in this case by the settling party. And again, we just feel that the idea of the Comparative Fault Act is to allow such settlements. And the provisions of that act were followed pretty strictly by the settling parties and the appellee in this case. And specifically,
Rubus, what is, I'm sorry, Ms. Rubus, what is the amount that your client claims that it's owed from Glenwood? In other words, what's the damages? What's the damages amount?
I'm glad you asked that question, Your Honor. The damages under our view of this case, and the reason the court granted a new trial, is that the damages remain undetermined. And the appellees will be left with whatever a jury properly decides are the damages in this case after deducting a credit for what's previously paid by the settling party. That's our view of it. And that was the court's view of it.
Well, and isn't that credit to be the pro rata share of the released party 100%, not the dollar amount of the settlement?
We agree with the court's view, even though there's been discussion in the case law about a so-called pro tanto credit not being consistent with the Comparative Fault Act. In our view, the language of Thomas versus Solberg even suggests that in this particular case, the 100% finding of liability against the driver, which is also the liability of the owner, results in a dollar for dollar credit for all amounts paid by the settling party.
Do you dispute air preservation? Can we reach the issue of the effect of the release? How did your opponent preserve air after the summary judgment ruling?
I don't have anything to add to the remarks of opposing counsel today in that regard, Your Honor.
At trial, who argued the fault of the driver? Was that something Glenwood attempted to prove?
At trial, it was almost uncontested. The driver bore some responsibility for the damages sustained by the appellees in this matter. The additional issue that was being discussed at trial lay in the claim under the premises liability portion of the claim as well. But as far as the owner liability case, to be quite honest, it was never, it never appeared to be much of an issue.
Counsel, on this pro rata versus pro tanto issue, so help me understand. Let's say, just hypothetically, that on retrial, the jury were to come back and find damages in the amount of $1 million, how much would you claim that Glenwood then owed in damages?
They would owe the difference between what was paid by the settling party against that judgment.
So
And I
they'd
think
owe
that-
$500,000, is that right?
The settling party paid more than that. It was a higher figure, $887,500. So they would be entitled, in our view and in the court's view, I think, to a credit in that amount. And it's tied in with the very language of 321.493 that makes it a little bit different in what is, we're calling this a comparative fault case, but I think at some point it's fair to ask, is it really whose fault are we comparing once you've had a finding of 100% fault by Jeff Jones? And maybe that justifies a little bit different treatment of the credit. And I think that's the only relevance of that discussion is what kind of credit. And as far as we're concerned, that we had kind of been settled, we thought.
Settled in the Solberg case.
Well, settled in our minds in this case, it certainly was settled when you've got an actual comparative fault situation as you did in Solberg. But in this case, we don't really have that, at least at this point. 668.3, subparagraph 4 talks about making these determinations after the jury has returned their verdict. And once, and Solberg had a multiple party comparative fault verdict, but this case really does not.
But good, would you agree until the jury answered the, allocated fault, you did have a comparative case that you were arguing the premises liability claim, and then that had to be compared with the driver's fault as a release party.
Certainly did, Your Honor. I couldn't agree more. But once that determination was made by the jury, and then we look at 668.3 that talks about making these determinations after the verdict is in, I'm just not sure of the relevance of that at this point. And that's why I question whether this is really a comparative fault act for certain purposes, or a comparative fault case for certain determinations by this court and, of course, for the trial court previously. I'd also like to respond briefly, if I could, to the general arguments made. It seems that the defendant in this case essentially argues that the release released them despite the language of the release specifically preserving the claim against this appellant as is directed and as we are allowed to do under the Comparative Fault Act. And the other argument that they make is that because the jury found their own driver, and it's their own driver under 321.493, 100% liable, that also lets them out of the case. Neither of those makes much sense to us. The simple fact of the matter is the Owner Responsibility Act makes them liable for all damages caused by their driver, which leads us into another question for this court to consider. And I know that the defendant is relying on the Bruce case, which I'd like to mention was decided several years before the Comparative Fault Act was even enacted in the state of Iowa, which I think is an important consideration. And to point out to the court that that court guessed about what your court would do with regard to two specific issues important to this case. One is whether or not the indemnity even lies between an owner of a vehicle and its consensual driver. And in our opinion, they guessed wrong.
Mr. Rivas, I have a question for you, if I could interrupt. You made a statement just a couple of seconds ago. You said it didn't make sense. The owner's responsibility makes them responsible for all damages by the driver. Are you saying that that settlement excluded some liability? Was it not completely wrapping everything up? Is there anything hanging?
Damages, Your Honor. Damages
Yeah,
are still
but as
hanging
far as the
and that's
liability.
critical. In terms of liability, certainly, because we're allowed to release, get a partial release from the defendant under the Comparative Fault Act, and that's what we did.
And indemnification language was in there as well. Okay.
No,
right.
we don't agree with the defendant's argument that indemnification language is in there other than to protect against claims against the monies paid by the settling party. If you look at the paragraph the defendant is talking about, and it's only with regard to medical bills and certain items that don't involve indemnification generally.
The counsel,
So to
how do you,
understand what you're saying, Mr. Rubis, and just so I fully understand, that your position in this case is that the way the owner liability statute works is it's entirely normal and acceptable that the owner could be liable for sums of money based on the negligence of the driver and have no recourse against the driver.
That is correct, Your Honor. For all intents and purposes, they're his insurer by language of the statute. And I cited some case law in the brief where this court has generally not allowed indemnification against your own insured.
so under your view, I loan my car to my neighbor and he drives carelessly, catastrophic accident. He settles cheap with the injured party. And then I'm on the hook for everything without recourse against my neighbor. I can't sue him for contribution anymore because he's a released party. How do we get around that dilemma? Or don't we?
I don't consider that a dilemma, Your Honor. I think you loaned your car to somebody that wasn't financially responsible. And that's the whole purpose of the Owner Liability Act.
Okay. Then the driver can cut off my right to reimbursement from the driver in your view.
Well, like Justice Laberato pointed out in the Thomas versus Solberg case, the amount of the settlement is irrelevant. The plaintiff may make a good deal or a bad deal. You'll find out later when the jury decides the case, but it falls only on them and it doesn't have much to do with anyone else.
Thank you, Mr. Rubis. We'll come back to you in a little bit. And
Thank you,
now,
Your
no, we won't, excuse me. Mr. Lapierre is the one who's going to reply. Go ahead.
May it please the court, opposing counsel, I think based on the questions, I think many of you have come to the very conclusion about this release. And what about the owner? What about the case where the driver decides to pay the injured person $1 and then leave the owner on the hook for the balance? The release is entered into. You can't get contribution from a released party. Apparently you can't get indemnity either. Doesn't that create those kinds of situations for the owner? And isn't that exactly what this is all about? We heard argument about
And in this
whole-
case, and let me interrupt for just a moment. And in this case, that agreement was struck between parents and a son, correct?
That's correct, Your Honor.
Yeah. And the
And they're
insurance company.
insured.
Okay, thank you.
And they're insured, and no doubt about it. And also, when we talk about what's the credit, I asked the question to the court that the appellee really never addressed. If we think about this hypothetically, the jury came in and said, Glenwood, you're 90% at fault. Jeff Jones, you're 10% at fault. Are the appellees or the court really going to take all that money they settled for and give Glenwood that credit? I think not under the comparative fault statute, because it's our proportionate share. So whether you talk about is this really a pro tanto or is it proportionate to the amount of fault, that's what this is about. And I would suggest to you in that hypothetical, we wouldn't be hearing about a pro tanto credit, well, you just reduce it, if 90% of the fault had been put on Glenwood by the jury as opposed to zero.
Mr. Lapierre, can I, related to that question,
Yes, Justice McDonald.
you cited a case out of Michigan, Kaiser versus Allen. And as I read that case, they seem to resolve the problem that you're raising and the problem of indemnity by saying these owner liability statutes really fall outside comparative fault when you're dealing with the situation of liability between the driver and the owner, and therefore you don't run into the indemnity problems, you know, that, and it's a very similar statute to ours. They have very similar case law. And I'm just wondering, am I reading that case incorrectly? And if not, why wouldn't that same rationale apply here? And we could resolve this as kind of a special liability statute outside the comparative fault regime as between these two parties.
Well, I don't think your focus is on the comparative fault. I think by definition, this is clearly a comparative fault case based on the way it was pled. There's no argument that the appellees thought Jeff Jones was at fault. There's certainly, as you would review this matter, clearly we argued that all the fault belonged on Jeff Jones. But by virtue of this release that was signed, and the court will have it in front of them, I think it's on page 31 of the appendix, it's pages 5 and 6. They specifically said in that release that they would have to indemnify, that is the plaintiffs, Jeff Jones, with respect, and there's certainly Medicare and all that in there, but it says any and all claims. And that would be what this would be on behalf of the owner, is that claim. So when he says it's our driver, I really think by virtue of the release, it's his driver. He made it his driver by virtue of that release. And I think what I would say in conclusion, as my time is wrapping up, I know there was some issue about, was error preserved? I think as the court reviews the record, we had been raising the banner about this release from the very beginning in the summary judgment motion, at trial and post-trial. But the court can see that in the record. And we've been raising that banner. And the only reason the banner didn't get raised is when the court issued the decision post-verdict and it said Glenwood owes nothing. We saw no point in arguing with it because we agreed they owed nothing. Now, how the court got there, we didn't agree with, as we argued later on. But I believe you will see in the record that we have been putting that banner out there that this release on the owner's consent matter and how it's framed and how it's driven and how it's with 668, it absolves Glenwood for Jeff Jones's proportionate share of the fault. Thank you very much to the court. I appreciate you hearing me.
Thank you very much. The case of Terry Jones and Christine Jones versus Glenwood Golf Corporation is hereby submitted. Likewise, the final case of the day, which will not have oral argument, is Donald Clark versus the State of Iowa. It is also submitted at this time. Bailiff, you may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.